We all knew it was coming, and sure as sugar, it's here. Class action lawsuit against China for what is going on in the world today. Viva Frei, Montreal litigator turned YouTuber, and it's time for another car vlog. Now, for those of you who've been following the channel for a while, you might have noticed that we actually have a new car. We went back to Subaru from our Ford Explorer because the new Subaru Ascent is actually an 8-seater, which is phenomenal. And the plus is that the lease is actually cheaper than the Ford Explorer, which allowed us to splurge on the sunroof. My wife and kids were adamant that we get the upgrade to the sunroof, and I was sort of a little reluctant because I said it couldn't be worth the extra $17 a month on the lease. But now I see how it actually helps cast the perfect light when shooting these car vlogs. It was almost meant to be. So what is going on? Well, I'm sure everybody in the world knows what's going on to some extent. We in Montreal are officially entering week 3 of the lockdown. And pretty much everywhere in the world, people are on lockdown in one form or another and have been for some period of time. Throughout North America, non-essential businesses have been shut down, and just recently, I think it was Monday of this week, our bar society managed to add to the list of essential services the services of lawyers. And that news could not have come early enough. Ever since this pandemic broke out, people have been asking, what is the likelihood of holding China accountable for this pandemic? I will not deny or delete old tweets where I predicted that the chances would not be great. There are just too many variables, factual variables, legal realities that make that type of lawsuit wishful thinking, to say the least. But apparently there are more adventurous lawyers out there, and there has in fact been a class action lawsuit filed in Nevada against China and the relevant bodies, and we're going to get into it in a second. Now, the lawsuit is long, it's heavy on the allegations, so I'm going to stick to the essentials of the lawsuit. But before we even begin, we need to talk a little bit about what the class action procedure is. It's essential to understand that the class action procedure is just that. It is merely a procedure, a vehicle through which people can sue. It doesn't change anything on the substance of the law. It is merely a procedural mechanism through which a number of plaintiffs, named and or unnamed, can sue an entity. The plaintiffs so grouped are referred to as a class. And depending on your jurisdiction, there are certain procedural requirements that are required in order to create the class, in order to name the class, in order to constitute the class. We will get into it later in this lawsuit, where there are allegations defining why the class is proper, how the class is to be defined, what the questions of law are for that class. But the essential bottom line as relates to the class, before we even get into the lawsuit, is that the class has to be definable. They have to share questions of fact as relates to the defendant, and they have to share damages, even if the damages themselves will differ from one plaintiff to the next. The class members do not have to have suffered the exact same quantum in damages. They can make evidence as to their respective damages later on. But they have to have sustained damages from the same cause of action that can be defined for the class members as a whole. So with that said, let's get into the lawsuit. United States District Court, District of Nevada, Bella Vista LLC, a Nevada Limited Company Liability, Greenfield and Company Inc., a Nevada Corporation, Life Real Estate LLC, a Nevada Limited Liability Company, Mobile Medics CPR LLC, a Nevada Limited Company, and DT Group LLC, an Illinois Limited Liability Company. Plaintiffs versus the People's Republic of China, National Health Commission of the Republic of China, Ministry of Emergency Management of the People's Republic of China, Ministry of Community Affairs of the People's Republic of China, the People's Government of Hubei Province, and the People's Government of the City of Wuhan, China. Defendants. So right now we have a group of plaintiffs who are in theory going to be members of the class if this class action is sort of approved by the courts. And then we have multiple defendants, all of which are located in China because it is basically the Chinese government. Introduction. This class action complaint is brought by the named plaintiff, which consists of small businesses in the United States, including the state of Nevada, and as defined by the U.S. Small Business Administration, for monetary and related damages sustained as a result of the coronavirus pandemic against the defendants, the PRC and its various government entities, which handled and managed the response to the discovery of the coronavirus and, upon information and belief, engaged in a cover-up of the coronavirus pandemic in China generally and within the Hubei province and the city of Wuhan, thereby causing and or contributing to the subsequent spread of the coronavirus all over the world, including to the United States of America and the state of Nevada. And then we have general allegations talking about the population of China, the economic relations between China and the rest of the world. And then we have various allegations as to the origins of the virus, things that are basically floating around in the news right now. I'm not going to go over each allegation specifically, but I am going to post the screenshot of the lawsuit right now so you can read through them yourself. And if you are currently reading through these allegations while listening to my soothing voice in the background, I'm also going to post a link to the lawsuit in the pinned comment in the comment section below so you can read through it in its entirety yourself if you feel so inclined. Just a few key allegations for context. Paragraph 9. Shortly after November 17, 2019, the PRC and the other defendants received credible scientific evidence confirming that this new virus, which first emerged in Wuhan, China, was very contagious, deadly, and capable of causing a pandemic. Upon receiving this disturbing scientific evidence and the data, the PRC and the other defendants had a responsibility to its own citizens, the World Health Organization, and the international community, including the citizens and businesses of the US and those in the state of Nevada, to immediately disclose this evidence. Instead of disclosing this evidence, the PRC and the other defendants engaged in a campaign of misinformation and lies. Upon information and belief, they engaged in a campaign of intimidation and arresting any Chinese doctor, scientists, attorneys, and/or reporters who tried to alert the public about this dangerous new coronavirus. As a result of the actions and inactions of the PRC and the other defendants, the international community, including the named plaintiffs, did not know about the severity and dangers of this new virus. Paragraph 14. The conduct and misconduct of the defendants has caused substantial monetary and related damages to the named plaintiffs and class members. These damages exceed hundreds of billions of dollars, and such damages will only increase in the future because many of these small businesses have been ordered closed or are working at reduced capacity. The defendants' conduct and misconduct has caused and will continue to cause the named plaintiffs and class members to suffer, among other things, reduced revenues, reduced profits, and/or the closure of many U.S. small businesses. Jurisdiction and venue, setting aside any execution or executability of any judgment, is going to be an issue in this lawsuit. All of the defendants are located in China, so what would be the nexus to instituting a lawsuit against them in the United States, specifically Nevada? Well, the allegations are there, so let's just walk through them. And incidentally, before we do that, let me open up these standard parentheses. All of the allegations in this lawsuit are just that, allegations. They are not yet proven facts, they are merely allegations that need to be proven as fact before a court of law. So in reading through this lawsuit, bear in mind that what is being alleged is not a proven fact as of yet. It is merely an allegation that needs to be proven true. And with respect to establishing jurisdiction and venue, the plaintiffs make the following allegations to justify that this lawsuit should be filed in the United States and more specifically in Nevada. Jurisdiction and venue. This court has subject matter jurisdiction over this class action pursuant to the Class Action Fairness Act of 2005 and 28 U.S.C. Section 1332D. The matter in controversy, exclusive of interest and costs, exceeds the sum or value of $5 million. There exists minimal diversity between parties, and there are over 32 million U.S. small businesses which are putative class members. And just to save you a Google search, putative means presumed class members. This court further has jurisdiction under the Foreign Sovereign Immunities Act of 1976, USC 1602, and particularly the exceptions of 1605 for acts outside the territory of the United States in connection with a commercial activity of the defendants that cause a direct effect in the United States, and 1605A5 for monetary damages for loss of property occurring in the United States and caused by the tortious acts or omissions of defendants or of any official or employee of defendants while acting within the scope of his office or employment. There is exception of jurisdiction under the FSIA for discretionary acts because the defendants have acted clearly contrary to the precepts of humanity, transparency, and/or their conduct is prohibited by the internal laws of the PRC and its provincial and municipal governments. Moreover, on March 19, 2020, the PRC admitted that the Wuhan police acted improperly when they intimidated and forced Dr. Li Wenliang, who was a whistleblower that exposed the existence and dangers of this new virus, to sign a false statement. This coerced false statement in effect had Dr. Wenliang deny that a new virus had been discovered and was killing people in China. Then the defendants used this false statement to mislead the international community, including the US, regarding the seriousness of this new virus and the immense catastrophe that it could cause to countries, people, and businesses all over the world. This court has personal jurisdiction over the defendants because they have caused tortious harm to the named plaintiffs and class members throughout the United States and in this district, and have sufficient contacts in Nevada and the rest of the US to render the exercise of jurisdiction by this court permissible. So these are all the legal arguments to establish jurisdiction such that the plaintiffs can in fact sue the People's Republic of China in the state of Nevada. One knows sure as sugar if the defendants actually appear to defend this lawsuit that they are going to raise the improper jurisdiction or the lack of proper form to institute this lawsuit in Nevada. Either way, one can reasonably anticipate an argument over the proper form for this lawsuit to be filed. Now, for expedience, I'm not going to go over each and every one of the allegations in the lawsuit. I'll flash some screenshots of some relevant pages of the lawsuit, but you can read the lawsuit yourself. We know or have pretty much a good idea of what the allegations of the lawsuit are. Above and beyond the allegations as to the origins of the virus and the impact that it is having, we're all very much aware of that. The interesting questions in law right now relate to the class. How is this class going to be defined? What are going to be the common questions of law that define this class? Class action allegations. The named plaintiffs assert national and Nevada non-commercial tort classes against defendants pursuant to Rules 23A, B, 1B, 2B, 3, and 23C4 of the Federal Rules of Civil Procedure on behalf of themselves and all those similarly situated. The named plaintiffs and class action plaintiffs define the national non-commercial tort class as follows. All similar businesses in the United States, including the state of Nevada, which have sustained, among other things, financial monetary damages and/or losses related to the outbreak of the COVID-19 virus. So the interesting thing here is that the definition of the class needs to be proper, concise, and accurate. It can't or ought not permit of any ambiguity as to who it includes and who it excludes by its definition. So here the proposed definition of the class is any small business in the US or Nevada that has sustained damages as a result of the outbreak. And I say proposed proposed definition because the court in fact has to authorize the definition of the class if it is a proper definition of the class. And then we have some exclusions from the class so proposed, which are very interesting to read, so let's just go through that quickly. Excluded from the class are the following. 1. The defendants and any parent, subsidiary, or affiliate organizations, and the officers, directors, agents, servants, or employees of the same, and the member of the immediate family of any such person. All small businesses in the U.S. who timely opt out of this proceeding. All small businesses that have been given valid releases releasing defendants from the claims asserted in this class action complaint. All persons who, prior to the filing of this complaint, have filed a non-class action claim against the defendants, or any of them, for the claims asserted in this complaint. And 5. The judges to whom this case is assigned, their employees and clerks and immediate family members. So some interesting procedural questions here. When it comes to class actions, some states have an opt-in and some states have an opt-out provision, meaning that if a class action lawsuit is filed in some jurisdictions, the plaintiffs would have to opt in, whereas in other jurisdictions they would have to opt out of that class action if they don't want to be a part of it. And we see from this exclusion that also excluded would be any plaintiff who have already taken a lawsuit against the defendants for the same reasons. They can opt in if they so choose, but they are excluded by the definition if they have already filed a lawsuit on their own against the defendants on the same basis. And then we have more allegations to further hit home why the class action is the proper procedure for this type of lawsuit. Paragraph 52. The class is sufficiently numerous, and as a result, the joinder of all members of the class in a single action is impracticable. There are over 32 million small businesses in the U.S., and a substantial majority of these small businesses and any of their affiliated entities have been or will be affected financially in the immediate future by defendants' wrongful conduct. There are numerous common questions of law and fact that predominate over any questions affecting only individual members of the class. Among these common questions of law and fact are the following: whether defendant's conduct was negligent and or reckless, whether defendant's conduct was clearly contrary to the precepts of humanity, whether defendant's conduct violated established laws within the PRC, whether the PRC's bioweapons labs are ultra-hazardous activities and caused the release of the virus, whether the PRC violated the rules and regulations of the WHO, and whether the PRC engaged in an intentional cover-up in order for the international community and the plaintiff class not to discover what was taking place with the COVID-19 pandemic. The claims of the named plaintiffs are typical of the claims of each member of the class in that, among other issues, the named plaintiffs' claims arise from the same course of conduct of defendants giving rise to the claims of other class members. The claims of the named plaintiffs and each member of the class are based upon the same legal theories. The named plaintiffs and each member of the class have an interest in prevailing on the same legal claims. And the defenses asserted by defendants will be very similar, if not identical, to all the named plaintiffs and class members. And there you pretty much have, in a nutshell, all of the allegations to illustrate and explain why the class action is the proper procedure through which this lawsuit should be filed. And it seems that in Nevada, like in other jurisdictions, the law firm itself has to prove why they are capable of handling a class action of this nature. The undersigned counsel are competent counsel experienced in class action litigation, mass torts, and complex litigation involving such widespread harm. Counsel will fairly and adequately protect the interests of the class. Now, this allegation is not here just to boost the ego of the lawyers who drafted this lawsuit. From what I understand, in most jurisdictions where class action recourses are allowed, the law firm who has filed the class action has to justify to the court that they are in fact competent and capable of handling the class action. So for example, as smart and capable of an attorney as I may be, if I were a solo practitioner petitioning the court to handle this class action, the judge might very well say, Viva, you're a smart guy and I like your YouTube channel, but I don't think you can handle a class action representing a potential of 32 million class members against the People's Republic of China. Sorry. If you want to join up and work with a specialty law firm or a big law firm that can handle such a lawsuit, fine, but I'm not going to authorize this class action for you to represent. So now you pretty much have a good idea of what this class action looks like. We have all of the allegations of fact. We have the proposed definition of the class. We have the allegations supporting why the class action is the proper procedural vehicle for this lawsuit. We have the common class issues of the defenses to be raised by the defendants and how they would apply equally to all of the plaintiffs. We have the commonality of the anticipated defenses of the defendants and how they would apply equally to all the class members. And we have allegations of the apparent competence of the law firm who filed this class action to appropriately and adequately represent all of the class members. That is the essence of a class action lawsuit, and now it will be up to the court to approve or deny the request. But before we get to the conclusions sought, I actually just want to specifically focus on count 2 because it's particularly interesting. Count 2, strict liability for conducting ultra-hazardous activity. Upon information and belief, the only 2 registered bioweapons laboratories in the PRC are located in the city of Wuhan, and one of them, the National Biosafety Laboratory at the Wuhan Institute of Virology, is the only declared site in China capable of working with deadly viruses and handles, according to various press accounts, covert military applications of viruses. Paragraph 69. The Wuhan laboratories are in close proximity to the wild animal marketplace where COVID-19 is alleged to have originated. Furthermore, it has been reported in the media that some Chinese researchers are in the habit of selling their laboratory animals to street vendors after they have finished experimenting on them, instead of properly disposing of infected animals by cremation as the law requires. And then the lawsuit goes on to allege why this is ultra-hazardous and clearly tortious conduct, as if we needed any further allegations to that effect. And I'm reiterating once again that these are merely allegations at this stage of the proceedings, but these are very interesting allegations if they can in fact be proven true. Then we have more standard allegations to the effect that the defendants knew or ought to have known that their negligent conduct would cause irreparable harm to the plaintiffs, etc., etc. It's par for the course in any lawsuit and predictable in this one. Let's just skip to the prayer for relief. Prayer for relief. Wherefore, the named plaintiffs, Bella Vita LLC, Greenfield & Company Inc., Life Real Estate LLC, Mobile Medics CPR Training LLC, and DT Group LLC, on behalf of themselves and as class representatives for all those similarly situated, demand judgment against defendants and pray for the following relief. A. Certification of the class under Federal Rule of Civil Procedure 23 and appointment of plaintiffs as representatives of the respective class and their undersigned counsel as class counsel. And here I should specify something that I forgot to mention previously. The class requires a class representative. Exactly like a class president, someone who represents the class, consults with them, but ultimately makes certain decisions for and on behalf of the class. The class representative, much like the counsel for the class, has to be capable of carrying out that duty. Duty. And the judge also has to approve of that representative for and on behalf of the class. B. An order requiring that defendants pay compensatory and other damages to plaintiffs and the class members for their economic and non-economic damages and losses identified herein to the full extent permitted by the law. An order awarding all damages allowed by any governing statutes or other governing law. An order awarding exemplary or punitive damages related to defendants' fraudulent, extreme, outrageous, malicious, oppressive conduct that was performed in conscious disregard of the health and safety of American citizens and Nevada residents. Statutory pre-judgment and post-judgment interest on any amount awarded, costs and expenses in this litigation, including but not limited to expert fees, filing fees, and reasonable attorney's fees, and such other relief as this court deems just and proper. Demand for jury trial. So that is the lawsuit, and it's going to raise so many legal, procedural, and political questions. Above and beyond the standard procedural questions like where should this lawsuit be filed? Above and beyond the most basic standard legal questions such as causation. Even assuming the plaintiffs get past all of these preliminary questions, what would even happen if they got judgment in Nevada? What assets do the defendants have in Nevada or the United States against which the plaintiffs could execute any judgment? Typically, when one obtains a judgment against a foreign entity with no assets in the country in which the judgment was rendered, they have to take that judgment over to the country in which that defendant is located. Not only do they have to take it over there, but they have to get the courts of that country to recognize that judgment and make it enforceable against the defendants. So in theory, what the plaintiffs could be left with here, even if everything goes as planned, is a judgment that they would have to take to the People's Republic of China, have recognized by the courts of the PRC, so as to be able to execute it against the defendant entities in China. Now, I'm not much of a gambler, but does anyone want to take any bets on the likelihood of that happening? And when I say that this raises political issues, this lawsuit, if it is doomed to fail in law procedurally or on the substance, might become something of a political or legislative issue. If all of these small businesses are left holding a very big bag, well, maybe it's going to be up to the government to do something about it. But we'll see. At the very least, now you know what the lawsuit says. And incidentally, if you like my videos and you like my content, please be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below. It helps feed the algorithm. If you want to support the channel, all support links are in the video description, so check those out if you are so inclined. And as difficult and stressful of a time as this is for everybody in the world, just bear in mind that this too shall pass and we will once again see sunnier days. And now you know your vlog. Peace out. Booyah.